All right. Good morning, everybody. Good morning. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the school offering this course for CE credit. This course is the 2021 Contracts Review. Drum roll, please. GAR versus the RE Forms. It sounds like a battle, doesn't it? The purpose of this class is to do a direct head-to-head comparison and contrast between these two sets of contracts. I will get into the notice of students in just a minute, but it is GREC course number 72775 through the Georgia Real Estate Academy, which is GREC school number 6915. I know nobody's gotten credit for this because this is the first time we are teaching it. So just a couple of housekeeping issues. This is a virtual broadcast of an approved class. So the way we take attendance and gauge interaction and your ongoing attendance is via the chat function. So if you have already done so, you do not need to do it again. If you have not done so, I need your name, your email address, and your real estate license number in the chat, and make sure you type it to everyone. We will need that 3 times now at the beginning of class, when we come back from break, and then once again before you leave the class. I will also ask you questions, not as many as I ask in an in-branch, in-person class, and I will need you to type your answers in the chat. The Zoom software does log not only who registered, but it logs your attendance, the time you are attending, as well as keeping a record of the chat. So we amalgamate all 3 of those reports to come up with a CE roster acceptable to GREC for 3 hours of CE credit. And the CE credits will be recorded within 3 to 5 business days. We're not going to email you. You just need to log on to GREC under your own login and check to make sure that it is there. So I'm going to type some information in the chat one more time, and we will get started. This class is, the way I'm going to present this class is a little different for those of you who have taken my classes before. I don't have a PowerPoint. I am just going to actually show you a table that contrasts the GAR versus the RE forms and the differences and similarities. And then I have handouts that will show you the actual forms themselves. We will email you the forms by tomorrow, so you will have copies of the forms with my underlines and all of those issues. Give me 1 second. All right. My name is Dana Sparks. I am the director of the Georgia Real Estate Academy, which again is the school offering this course for CE credit. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. The only reason I tell you my day job, so to speak, is because this is a contracts class. So I do see contracts on a regular basis. Now, I'm not our compliance broker, so I don't see every single contract. I just see the ones that have questions or issues or some issues. So, you know, I don't see very many at all, right? Anyway, I just wanted to give you a little bit of context regarding my interaction on a regular basis with contracts. I am a non-competing broker, meaning I do not interact with the public anymore. I don't help sellers list, and I don't help buyers buy. I just broker and teach and manage. So we are going to get started. If you guys have any questions, please type them in the chat. I will stay after class for as long as needed to answer your questions, and we will take a break. So I am going to share my screen and we will get started. All right, everybody saw that. So here we go. Feedback. All right. Let's see if everybody can see that. It looks like it. All right. So let me read the notice to students and then I will show you guys how we're going to do this. So 2021 Contracts Review, GAR versus RE Forms. Notice to students for the virtual broadcast of a continuing education class of a GREC-approved classroom class. The Georgia Real Estate Academy, school number 6915 with the end date of renewal being December 31st, 2022, presents to you the following course of study. Should be 2021. 2021 Contracts Review, GAR versus RE Forms. This is the correct course number, 72775. It is a virtual remote broadcast of an approved in-class course, 3 hours in duration, approved by GREC 4CE. No prerequisites. I am your instructor, again, Dana Sparks. No homework, no written exam. Students must be on time and present for all the remote virtual broadcast instruction hours in order to receive credit for the class. Roll call and documentation of your license number will be conducted by the chat function at the beginning, end, and after all breaks. You may only receive credit for a specific course number once every 12 months. Again, this is the first time I am offering this course, any of us through the school, so there should be no issue there. And no recruiting for employment opportunities for any real estate brokerage firm is allowed in this class or on school premises. Record promptly any effort to recruit on behalf of a brokerage firm by anyone to me, the director of the Georgia Real Estate Academy. Heidi Kelly is the coordinator of the Georgia Real Estate Academy, and there's her contact information, or the Georgia Real Estate Commission. All right. So this is how we're going to do it. This first handout has a table. And on this table, I've got whatever the issue is or the topic, how GAR addresses that topic, where in the GAR contracts, the actual form number and the paragraph, how the RE Forms addresses this topic, and where in the RE Forms you can find it. So this handout is a huge, long, it's a 14-page document, table comparing what we're going to go over. Then I'm going to flip back and forth. This is a handout, and you will get these handouts via email after class. This is, see where it says handout number 2 of 3? This is the package of the actual GAR contract forms with all of my underlines and my notes, so I can show you exactly where it is that we're talking about. And then this handout number 3 of 3 is the RE contract forms, and where with all my notes and underlines and where you can find everything. So I hope you don't get dizzy or seasick as we flip through everything, but it's just easier to do it this way rather than cutting and pasting for a PowerPoint presentation. And again, you will get these handouts after class, including the that table. So why am I focusing on GAR versus RE? Well, there are a huge number of real estate contracts out there for you guys in Georgia to help buyers and sellers transact business, do business, to convey property. The reason we focus on GAR and RE, well, let me talk first. There's GAR, there's RE, there's HUD contract forms, there's new construction forms, there's attorney written contracts, there's investor contracts, there's Fannie Mae contracts, there's all kinds of contracts. The GAR and the RE, GAR stands for Georgia Association of REALTORS. These contract forms are the two primary forms that you guys as agents have readily available access to initiate an offer or a counter offer. Some of those other forms you might have access to, you might not have access to, or you have access to fill in the blanks. Well, these two, but you don't necessarily readily have access to initiate an offer on one of those other forms. You are usually receiving an offer or responding to one of those forms. So that's why we're focusing on the GAR versus the RE. So we are just going to dive in. Again, I welcome your questions, and through the chat, I will address them. We have a lot to cover. So we are going to take the whole 3 hours, and we'll take a break about the halfway point. All right, here we go. Ready or not? Everybody sit back and enjoy. All right, first thing, the date on the forms. So the GAR contract package, they update, the GAR Forms Committee updates their forms semi-annually at the beginning of the year, and then they do a mid-year review. And you will see on the GAR contract package, you will see, I'm trying to make this a little bit bigger for you guys. You will see this date. See how this says 2021 printing? And down at the bottom, you'll know if it's the initial release of the contract or the mid-year, because it will say if it was changed mid-year. See how this says 1/1/21? If it was revised mid-year, it would say something like 5/1/21. The RE forms, however, only have the date that form in and of itself was last revived. So this is the actual RE form, contract for purchase and sale of real property. And you'll see at the bottom 2019, because that was the last time this form was revised. Now, one of the things I should probably have put it in here, the GAR, part of the GAR licensing agreement is you must be an authorized user of GAR. And you do that, you become an authorized user either financially because you are a member of a board. And so the Georgia Association of REALTORS gets dues money and they don't charge you anything extra for the contract, or you pay GAR for the license to use their contract. Or if you are a co-op agent with your signature on the signature page, the other agent may share a blank GAR form with you. The GAR, part of the licensing agreement for GAR is that once these new forms come out, it is against their licensing agreement to go back and use a previous version. So it is a violation of the license if you go back and use any forms that say 2020 or any previous year on them now. Now, that doesn't mean you need to go and actually redo any listing agreements you have. If you still have listings available from December, something's up. Or any purchase and sale agreements. It just means if you're initiating a form from now on, you must use the 2021 version. The RE forms, they don't have any information like that at all in their licensing agreement. So you would just use whatever form is the last time it was updated, and you do not have to pay to have access and use the RE forms. Both of them you access somewhere, typically through your MLS service, or there are some software packages, but generally that's where you can access both sets of forms. All right, fill in the blanks. In the GAR, for the majority of their forms, they have put all the fill in the blanks on the first or second page of all the forms. Primarily, we're just primarily going to cover the purchase and sale agreement and some of the main exhibits and amendments, or whatever the differences are. In the RE forms, the fill in the blanks are throughout the forms themselves. Number of pages. GAR currently is a total, the purchase and sale agreement is a total of 8 pages. The RE forms, now this is something very interesting that they do. It is really 10, 11, 12, 13, 14 pages. The RE forms has a contract, which is RE 100, and RE1, which are standard terms. So let me show you that just for a minute. Well, here's GAR. All the fill in the terms on the front page, it's 8 pages, and then all the legalese is in what they call the corresponding paragraphs for Section A. In the RE Forms package, this is the actual contract with the fill in the blanks. This is a 5-page document. So the fill in the blanks are throughout the page, but there's not a whole lot of legalese. So where do you get the legalese, or what you think of as the corresponding paragraphs? Well, in the RE package, there is another document called the standard terms for the purchase and sale. The standard terms are, well, let me go back up to the contract itself. So this is the contract that you fill in the blanks and your buyers and your sellers sign. You identify the buyer and you identify the seller. Then in bold font, all caps, it says, this contract incorporates by reference those certain standard terms for the purchase and sale of Georgia real property published by Orthros Real Estate Enterprises, LLC at, here is a public website where anybody, especially your public, can go and get the document called the standard terms, reformsga.com. And in effect, as of the offer date, the standard terms become a part of the offer and are incorporated by reference. When each party, meaning buyer or seller, affix his or her signature to this actual contract, this 5-page contract, they expressly agree that they have read the standard terms and that it is their intent that the standard terms are incorporated as part of this contract. That means when they sign this 5-page contract, they're saying they've gone online to this website, they've read these standard terms. Point of practice to you real estate agents. You guys have access to, and I'm trying to not make you dizzy, to this document called standard terms. You have, this is what's on the website for the public to go get. You guys have, as agents, you have access to this document wherever you access your forms. So where you access your purchase and sale agreements, exhibits, and amendments, you have access to this. Again, you are all independent contractors. I suggest you protect your license as well as provide good customer service. Download, pull down this from your package, from your, online, either Remind Docs Plus through FMLS or Transaction Desk through Georgia MLS. Reference it as an exhibit and attach it to your contract, because this, like I said, is all the legalese. This is what happens with the earnest money. This is the type of title that's conveyed. This is what happens if the buyer fails to remit the earnest money. This is what the seller has the right to do if the buyer doesn't remit the earnest money. This is what happens if the property doesn't appraise. All of this stuff is very vital information that your clients are going to need. So again, as part of your customer service, being a good real estate agent, I strongly suggest that you download it just like you would any exhibit in the purchase and sale and reference it as an exhibit because it's incorporated anyway. All right, lost your audio. Can you still hear me now?
Yes.
Can you guys hear me? Okay, thank you. All right. So that's why I say the RE contract really is a 14-page purchase and sale rather than 8. All right, in the GAR contract, there are a variety of very specific forms for very specific situations. In the RE forms, they are more multi-use. For example, they have just a general amendment, and that can be used to amend a brokerage agreement. That can be used to amend a purchase and sale agreement. That can be used to amend a lease. It's one document, and you indicate on there what it is that you are amending. Whereas in GAR, you have one amendment for the purchase and sale, one amendment for the brokerage, so forth and so on. All right, diving into the meat, purchase and sale. Names of the parties. In the GAR, this first column is GAR. Here's the form and the paragraph number. This is the RE forms and where you can find it there. In the GAR contract, the names of the parties are only on the signature page. In the RE forms, the names of the parties are the very first thing after the offer date, name of the buyer, name of the seller. Now, for initials, however, there is an initial space in the GAR at the bottom of the first page. And in the RE forms, there is a place to initial every page. So here's the GAR, and here's a place where the buyer initials and the seller initials. In the RE forms, they initial at the bottom of every page. All right, sale price. In the GAR, you just put in numerals. In the RE forms, you put in numerals and words. You guys, this is not a line by line going through each contract. This is just pointing out specifically the differences. So anytime in the GAR contract where you talk about the price, see how it's just a dollar sign? That calls for numerals, closing costs, dollar sign numerals. In the RE forms, purchase price, it has a place for numerals, and this long line means you spell it out in words. If there's a discrepancy between the words and the numbers, which takes precedence? Type it in the chat. Words, words. Yes, you guys are correct. If there is a typographical error or something that somebody cannot read, if it's written out in words and in numbers and there's a difference, the words will take preference. All right. Closing costs. In the GAR contract package, there is a specific dollar amount that you must fill in for closing costs. In the RE forms, you fill in a dollar amount or a percentage of sale price. So let's look at that. Again, this is GAR. Closing costs, you just fill in a dollar amount, numerals. Remember, anytime there's a dollar sign preceding a blank, you would fill in with numerals. In the RE forms, all right, we've got closing costs on a different paragraph, paragraph 5. You fill in either a percentage of the sale price or a dollar amount. Isn't that interesting? Well, it is interesting because if you fill in a percentage of the sale price, if the buyer and the seller counteroffer and negotiate a different sale price, then if they are binding on the RE forms, the amount of seller's contribution to buyer's closing costs change commensurate with the negotiated purchase price because it's just a percent of whatever the purchase price ends up being. On the GAR form, you sort of have to get out your crystal ball and try and figure out what the final sale price is going to be. And in this market right now, this is February 2021, wild, wild west out there for buyers with the dearth of inventory we have. Then the closing costs, you either have to remember to counter the closing costs in addition to the sale price, or try and, like I said, use your crystal ball to determine what the final sale price will be. For those of you that have been practicing real estate in Georgia for over, I don't know, 20, 25 years, you are starting to see that the RE Forms contract package looks a lot like the GAR contract package from years ago. Years ago, GAR used to have all the fill in the blanks within the purchase and sale agreement. GAR used to have words and numbers for the sale price and the closing costs. GAR used to have closing costs as a percentage of the sale price or a flat dollar amount. So it looks very similar for those of you who have been practicing for many years, like myself. All right. Now, holder of the earnest money. If the in the GAR contract package, it specifically states that if there is a closing attorney holding the earnest money, it requires that you also use GAR F510 as an exhibit and F511 as an agreement signed by the closing attorney. In the RE forms, there is nothing noted if it is not the seller or the buyer's broker. So here's where it is in GAR. Holder of the earnest money, paragraph 5. I guess you guys can see that. There we go, a little bit better. If the holder is the closing attorney, F510 must be attached to the exhibit here too, and F511 must be signed by the closing attorney. In the RE forms contract package, where it talks about the holder of the earnest money, it just says the earnest money shall be payable to, that's whoever the holder is. And there is absolutely no reference if it is somebody other than the brokers. Why do I say someone other than the brokers? Well, the reason is when you are an affiliated licensee, you are affiliated with your broker. All contracts are written in the name of the broker. And when a broker decides to accept you on their roster in their firm, in essence, they give you their permission to sign contracts on their behalf. And if your broker is identified as the holder of the earnest money, then your broker agrees to fulfill all those responsibilities outlined in the purchase and sale agreement, what those responsibilities are. For example, as holder of the earnest money, as a broker, once you sign, I give you permission to sign my contract, locking me into those responsibilities. That means, number one, I need to make the deposit of the earnest money. Number two, if I never receive the earnest money, I must send notice to the parties that I don't have it. Number three, if there's a dispute over the disbursement of the earnest money upon termination, I have several remedies available to me to decide what happens with those trust funds. So when you sign the contract, it's the same thing as your broker signing the contract. Where in the purchase and sale agreement itself do you see a signature place, fill in the blank, for a closing attorney as the holder of the earnest money? Tell me where you see that. Purchase and sale agreement. Any purchase and sale agreement. If you identify the closing attorney as a holder of the earnest money, where do they sign? Anybody? Crickets.
Is that on RE or GAR?
Anywhere, either, any contract.
If it's on GAR, isn't it a different form?
In the purchase and sale agreement. Purchase and sale agreement.
If it's on GAR, the attorney signs the F511.
Where on the purchase and sale agreement?
Oh, it's not on there.
Oh,
it's a separate.
Exactly. Nowhere. That was sort of a trick question. The closing attorneys do not sign. They are not a party to your contract. In the GAR-E in and of itself, in the GAR-E, in the GAR in and of itself, or in the RE forms. That means if you guys put down that the closing attorney is the holder of the earnest money in the GAR, and you do not include, they do not sign the F511, they don't have to perform any of the responsibilities as holder of the earnest money. In the RE form, there is nowhere for them to sign agreeing to fulfill any responsibilities as holder of the earnest money. Neither is it in the HUD contract, new construction, any of the other contracts. In essence, you guys are having your buyers give a closing attorney a check or whatever form, thousands and thousands of dollars, and they don't sign. There's nothing that they have to do with it. They're not required to deposit those funds. They're not required to let anybody know if those funds aren't good, if they bounce from the bank. If there's a dispute over the contract terminates and there's a dispute over who gets them, they're not required to do anything. The buyers are just giving the closing attorneys a check for thousands and thousands and thousands of dollars. They're without any paperwork attached. It's absolutely crazy. So the GAR contract package recognized this about 4 years ago and created a form. What we have now in the GAR contract package, this is an exhibit. This is the closing attorney acting as the holder of the earnest money. This has what happened, so forth and so on. You must identify an alternate holder who has to be one of the brokers. It must be the listing broker or the selling broker. And this is where you just identify the closing attorney. Again, nowhere on this form does the attorney sign. This is just so the parties go binding, identifying the closing attorney as the holder. Now this form, this is the F511. And this form is an agreement of the closing attorney to serve as holder. There is a time frame within which the closing attorney must sign, and this is where the closing attorney signs. This is not available in the RE forms. This is just a GAR form. And the closing attorney basically says that they agree to fulfill all the responsibilities as holder of the earnest money. They agree to make the deposit. They agree to send notice, so forth and so on. If they don't agree within 3 business days after going binding, then the alternate holder becomes the closing attorney. But again, this is only something available in the GAR contract package. So if you guys identify the closing attorney as the holder and never get this signed, well, number one, you need to have the F510 sign, a part of the exhibit, and you need to get the closing attorney signed. If not, then again, your buyers are giving these attorneys a check with no strings attached. Now, obviously, the closing attorney can't steal the money. There are civil laws regarding what somebody can do, but in essence, they're just giving, here, give me a check, give me thousands of dollars with no strings attached. Question, is there an RE form? No, there's nothing for the RE forms. Can you write a special stipulation? Well, that doesn't do you any good either. A special stipulation on the purchase and sale agreement is signed. The purchase and sale agreement is signed by whom? It's signed by the buyer and the seller. Still, closing attorney is not signing your purchase and sale agreements. Point of practice, you guys. If you're having a closing attorney as the holder of the earnest money, you better have a chat with that closing attorney and find out what their policy is. Get with your broker or with an attorney, perhaps to get them to sign something agreeing to fulfill the responsibilities as holder as outlined in the purchase and sale agreement. Now, another issue. If your parties go binding on GAR, it specifically states the closing attorney, if the holder is the closing attorney, what if the holder of the earnest money is an attorney, but not the closing attorney? For example, in a lot of foreclosures, there is a law firm here in Metro Atlanta that handles many of the foreclosures. And we've seen contracts where that law firm holds the earnest money, but they are not identified as the closing attorney. Well, if that's the case, it is the same thing, because this F511 is signed by the closing attorney. So just something to keep in mind. All right. Where are we? Form of the earnest money. So in the GAR contract package, the earnest money shall be paid by check, ACH. ACH is brand new for 2021. Cash or wire transfer of immediately available funds. In the RE forms, the earnest money is in the form of a check, certified funds, money order, or cash. So certified funds would, in essence, include a wire, because a wire would be certified, as well as a bank check. Nothing about ACH in here. For you guys in the Metro Atlanta area, none of our closing attorneys will accept an ACH, and very few brokers will accept an ACH. GAR added that in 2021 because there are brokers and closing attorneys in other parts of Georgia that do accept an ACH transfer of funds, which is electronic transfer of funds. All right, due diligence period. In the GAR form, you negotiate the time frame for the contingency. Same thing in the RE form. But in the GAR contract package, there is a separate fill in the blank section if the buyer and the seller negotiate for additional option money for this due diligence period. So here we are on the GAR, paragraph A8, inspection of due diligence. Time frame, that due diligence period is X number of days from the binding agreement date. And there is, in consideration of the seller granting the buyer the option to terminate, they can pay, the buyer may pay the seller additional option money of blank, and that's when it is to be paid directly to the seller, and they can negotiate if that additional option money is or is not applied towards the purchase price. In the RE forms, where it talks about the buyer's right to terminate, is the exact same thing as the due diligence period. There is just information, fill in the blank, about the time frame. There's no negotiation of additional option money within the pre-printed verbiage itself. Obviously, you could write that in as a special stipulation. GAR does not allow money orders. GAR allows money orders. You can do a money order for earnest money in GAR. That would, in essence, be cash, I guess. There are a lot of brokers that have accept money orders for earnest money. All right, moving along. Labels for the brokers. ACH, I don't remember what the actual acronym stands for. In essence, it is an electronic transfer. It electronically transfers funds from the public's actual checking account directly into the account of the holder. The issue why a lot of Metro Atlanta brokers and closing attorneys will not accept ACH is it is reversible up to 6 months, whereas a wire is not reversible. Thank you, Zoe. Automatic clearinghouse, that's what it stands for. All right, labels for the brokers. This is throughout both sets of contract forms. Brand new in 2021, they are referring to the brokers as the seller's broker and the buyer's broker, where it used to be called, this is the buyer's broker, and that used to be called, again, this is brand new for 2021 in GAR, it used to be called the selling broker. The broker working with the buyer used to be called the selling broker, it's now called the buyer's broker. And the broker working with the seller is now called the seller's broker, and it used to be called the listing broker. So listing broker, seller's broker, that one was pretty readily understood. It was really confusing. Why is the broker and agent working with the buyer called the selling broker? They're not selling, they're buying. So GAR made that change this year throughout the contracts. They're referring to the brokers differently. And in the RE Forms contract package, it definitely talks about anywhere where it references the brokers or the agents. This has been from the beginning of the RE Forms, which were born in 2012. It does reference the buyer and agent working with the buyer as the buyer's broker, and the broker and agent working with the seller as the seller's broker. That has always been the case with them. All right. Now let's look at what is the actual deed that is conveyed. In both, it is limited warranty deed, and the title is good and marketable title. So in the GAR, under the corresponding paragraph where it talks about the warranties of the seller, it does specifically say that the seller will convey good and marketable title by limited warranty deed, and further down it describes or defines what good and marketable title is. In the RE Forms contract package, let me see where that is. It is not in the actual purchase and sale agreement, which is RE 100, but the type of title and that is conveyed and the definition of it is in the standard terms, which is RE1. And it states down here, again, I'm sorry if I'm trying to not make you guys dizzy. It does state, oh, where am I? RE11. Okay, I missed it, very beginning. It does state the seller shall convey to the buyer marketable, good and marketable title by limited warranty deed, and then it defines what good and marketable is. So that is the same in both of them. Now, closing costs. So if a seller is making a contribution to the buyer's closing costs, what can they be used for with respect to the purchase and sale agreement? Very different. This is, well, not very different, but a little bit different. In the GAR contract package, it states that whatever the mortgage lender can use that seller's contribution for, but anything that cannot be used by the lender goes back to the seller. In the RE forms, it says that whatever financial contribution the seller has identified as contributing to the buyer's closing costs may be used by the buyer for any purpose whatsoever, and they even use the words merely at the discretion of the buyer. So in the GAR contract, here's where it says B3. It says what the lender can use them for, and then it specifically states any unused portion of the seller's monetary contribution shall remain the property of the seller. In the RE forms, again, all of this information is in the standard terms. I cannot impress upon you agents enough to, when you are going, when you're writing an offer, when you are accepting an offer, when you're countering an offer, when the parties are going binding on the RE forms, you really, 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 really need to include this document of the standard terms. So everybody's on the same page regarding what the legalese is, or what they are agreeing to when they signed the actual purchase and sale agreement. So here's where it talks about the closing costs, paragraph 5.5 on the standard terms. I'm in the RE forms. And it says, same thing, the lender has to use them for lender purposes, underwriting criteria. And then it says, may be used for any purpose whatsoever to offset costs, so forth and so on, or merely at the discretion of the buyer. So in other words, whatever the dollar amount is, the seller is contributing that to the buyer. The buyer can use them to pay a home warranty. The buyer can use them to pay HOA dues out into the future. They can use them to pay for hazard insurance, whatever, above and beyond closing costs, escrows, and prepaids. In the GAR, it is specifically limited, and anything not used goes back to the seller. All right, prorations. This is the same. The fees are to be prorated at closing based on any estimates that the closing attorney gets. This is specifically with respect to, for example, property taxes. And so the closing attorney, if the bill has not come out for this calendar year, which they don't come out till the fall, the closing attorney typically will use the last bill available. When the actual bill comes out for this year, if there were any differences, the parties agree to prorate those differences between themselves. Ha ha, like fun. That is the same in both GAR and RE. However, brand new in 2021 for GAR is they've added a section about liability for property tax that lies with the buyer. So let me show you where that is in GAR. That is under this section, Prorations. And it says, again, Prorations. And again, it does say, I don't have all this underlined, but it just says the parties are asked to make financial adjustments between themselves as necessary to correctly prorate the tax bill. Brand new for 2021, it says in the GAR contract, the liability to the county in which the property is located for ad valorem real property taxes for the year in which the property is sold shall be assumed by the buyer as soon as you close. Buyer agrees to indemnify the seller against any and all claims of the county for unpaid ad valorem property taxes in the year in which the property is sold. In the RE Forms contract package, where it talks about the prorations, it does talk about prorations. All it says is that basically the closing attorney for taxes, homeowners dues, anything that has to be prorated, if they don't have the actual bill for the calendar year in which it is closing, then the closing attorney is using estimates based on previous bills. And when the current bill comes out, if there's anything that's different, the parties agree to prorate them between themselves. Now, nothing about liability in the RE Forms contract package. I will tell you guys, depending on the closing attorney, there are many, not all, but there are many closing attorneys that will have an additional document that the buyer signs at closing that encompasses this verbiage about liability to the county if upon closing. So this verbiage might be included by the closing attorney, even though it's not in the contract for the RE forms or HUD or new construction, so forth and so on. That again would be a closing attorney document depending on the closing attorney. All right. This is a huge, huge difference between these two contract forms. If there is a delay in closing, how is that delay handled? Well, in the GAR contract package, there is a right for either party to unilaterally extend the contract for 8 days. How many signatures are required if it says unilateral? Type it in the chat. How many party signatures are required if it says unilateral? 1. You guys are correct. Unilateral. That's why unicycle, it only has one wheel. Unilateral, 1 signature. Now, I mean one side signature. If you've got 2 buyers, then they both have to sign, but one side of the contract unilateral. In other words, one party is extending the contract, the other party is held in contract against their will. Why do I say against their will? If they agreed to it, then it would be a bilateral or an agreement to extend done by an amendment, which requires both sides' signatures. Unilateral, somebody's being held in it against their will. In the RE forms, if there is a delay and the contract needs to be extended, it must be done mutually. You must extend it by an amendment with both parties' signatures. So let me show you first where that is. So here we are on the GAR. And this is where it talks about the closing date and possession, the right to extend the closing date. Buyer or seller may unilaterally extend the closing date for 8 days upon notice to the other, but there are very, very specific reasons. There's title reasons. If there's a valid title objection, as long as that title objection is not something that can be satisfied financially. For example, if there's an issue with the title, but it's a lien on title, that can be satisfied financially. That is not a valid reason for a party to unilaterally extend. It's just if there is a title issue like a cloud on title, the proper chain of title hasn't been fully cleared, so forth and so on. Also, if there's an issue with title where the seller cannot convey good and marketable title, then either party may extend the contract 8 days for 8 days. If there are loan issues, if there is a holdup either by the closing attorney or the lender and they are delayed and they cannot fulfill their respective obligations, as long as that delay is not caused by the buyer, then you can use the 8-day unilateral. Or if the buyer has not received the federally required TRID estimates, and that's what it says, not received required estimates. So the closing attorney and the lender may not close. They are federally prohibited from closing a contract if the lender has not sent out to the buyer the TRID, Truth in Lending RESPA integrated disclosures of the financials from the lender. Now, it's not the end financials, but it's certain things that can't change. Now, that is, and the right to unilaterally extend can only be used one time per contract. So very specific reasons, and it can only be used one time. But what do we do with this issue, this federal regulation? Because even if the parties are binding under this, under the RE Forms contract, we still have to deal with, by federal regulation, the closing attorney or the lender cannot close it if the lender has not sent out the TRID disclosures to the buyer. So here is where that is addressed. It is addressed in the RE Forms standard terms. Under the main paragraph is financing contingency. And it's this paragraph 6.3.2. And basically what this says is Fannie Mae, Freddie Mac, FHA, USDA, VA, so forth and so on, mandate compliance with the law. So if the whatever the lender guidelines increase in costs or expenses to the seller, or the date of closing. So by the date of closing, that would mean if the lender hasn't sent out those TRID disclosures, they can't close on the contract closing date. So that's going to affect the date of closing. Then there's not a unilateral right to extend, but the seller has a unilateral right to terminate the contract. So if guidelines mandate are going to affect the date of closing, and again, that's specifically referencing the TRID disclosures not being sent out by the lender to the buyer, then the seller, so first of all, the buyer needs to notify the seller, look, we can't close on our closing date. We have to close on a future closing date. Like, let's say we were scheduled to close today. We can't close today, February 23rd. We have to close on March 5th. So the buyer first has to send the seller notice, and then the seller, at the seller's sole discretion, can say, nope. The seller has 3 days. Let's say the buyer sends that notice today. The seller has 3 days to say, nope, I'm not waiting till March 5th. I don't care that your lender didn't send it out. You should have chosen a different lender, or you should have been on your lender a little bit more forcefully to get those out. I am terminating the contract and going on with another buyer. If your seller does not terminate within those 3 days, then the seller is deemed to consent to those changes, and we agree to close on March 5th or whatever I used in my example. Big, huge difference between one is extension of the contract, one is a sole termination right by the seller. Will the buyer get their earnest money back? Interesting question.
I think they should.
You know, that's an interesting question. I can't believe nobody's ever asked me that before. Let me think about that. I don't want to give an answer right now. I'm thinking that it is not.
Because it's not the buyer's fault, is it necessarily?
Well, the buyer chose the lender. So I think that would end up being left to the interpretation of the holder, because on one hand, the buyer should have made sure that the lender got that done prior to the end of financing contingency. But on the other hand, I think that would fall under other lawful reason because it can't close. I am leaning, again, this kind of issue would be up to the discretion of the holder of the earnest money if the parties don't agree on a TNR on the release portion. But I am thinking, because it is, I'm thinking out loud, I'm thinking because it is a federal regulation that the reason for termination would be other lawful reason. I mean, yeah, I think the buyer's earnest, okay, I'm making a definitive broker. Again, it's still up to the holder of the earnest money, but as a broker, it is based on, it is nothing that the buyer has or has not done. Yes, the buyer chose that lender, but the lender and the closing attorney are federally prohibited from closing that transaction. So I think that would be, for the reason for the termination would be other lawful reason. And I think the buyer should not be penalized for not being able to close. The seller just, because the seller doesn't have to terminate. So, yep, I think the buyer would get their earnest money back. That is my broker opinion. If I was the holder of the earnest money, that would be my interpretation of that. Great question. Nobody in all these years has ever asked me that. So, yeah, no, due diligence doesn't have anything to do with it because that's not a due diligence thing. It is a federal regulation. The only thing that the other reason why I could see the buyer potentially losing the earnest money is, again, not all lenders miss that deadline. The buyer chose to go with that lender. So I could see that potential interpretation. And again, it would be up to the holder to make that interpretation, which we'll get into in just a little bit. All right, moving along. Great question. Earnest money, the time frame. So in both contract packages, the buyer and the seller negotiate when the buyer is to remit or send the earnest money to the holder. But the difference is pre-printed that once the holder receives it, how long do they have to actually make the deposit? In the GAR contract package, it states right here, holder of earnest money, the holder has not later than 5 banking days. Let me see if I can get a pointer. Let's see. Closing attorney has, the holder has 5 banking days to make the deposit. In the RE Forms contract package, where it talks about, I got to go way back up here. They're just in a little bit different order. So again, I'm trying to not make you guys seasick. Where it talks about the, when the holder is to deposit the earnest money. I got to go back to my cheat sheet. Oh, it's back in the purchase and sale. Anyway, it says 3 banking days. So GAR's 5 banking days. The RE form is 3 banking days. Again, that's for the holder to make the deposit. Both of them you negotiate when the buyer is to send the funds to the holder. Now, what happens if the earnest money, either the buyer never sends it or it is not honored by the bank? And it's not honored by the bank either because there's no funds there, it's insufficient funds, or sometimes if there is a check written on a low check number, there are some banks that won't accept the check based on the check number. So if it isn't honored by the bank or the buyer never remits it, then it is all spelled out here in this paragraph and in the RE forms. It is spelled out what happens. The buyer has 3 banking days to cure the default, meaning they have to make good on those funds within 3 both of them call for the holder of the earnest money to send notice to the buyer and the seller that, look, we don't have the money. Either we never got it or it didn't clear the bank. But regardless, those funds are not on deposit with us in our trust account. So from the date of that notice, the buyer has 3 banking days to cure that default under GAR. Under the RE form, they have 3 calendar days. So if you get that notice, let's say on a Friday, and you're binding under the RE forms, you've got Saturday, Sunday, and Monday. Well, if Monday's a federal holiday, that buyer better get to the bank before 12 noon on Saturday, or go get a money order, so forth and so on. So very different. If you get that notice on a Friday under GAR and Monday's a federal holiday, then you have a little bit more extended time for the buyer to cure that default. If there is no cure, both contracts allow for seller termination rights, but there are notices and time frames involved. And again, that is all spelled out in the GAR contract package. Here is where it is spelled out under the purchase and sale agreement, under the earnest money. If the funds aren't good and the buyer doesn't cure, here's where all of that is spelled out, the seller's rights. In the RE forms contract package, all of that is spelled out again in the standard terms under this paragraph 3.3 that the seller can terminate. If the seller doesn't terminate, you guys, then you just go on with the contract. Is earnest money required for an enforceable, non-voidable, valid purchase and sale agreement for a buyer and a seller to convey property? Is earnest money required? Type it in the chat, yes or no. Is earnest money required for an enforceable, valid, non-voidable contract between the parties? Correctamundo, no. The answer is no. The earnest money is not a consideration of the contract and it is not required. So if there are some contracts where there's $0 earnest money, in this situation where the earnest money was never remitted and was never cured, the seller does have the option of continuing on and the parties just go to closing. Now, obviously, the buyer is going to have to bring additional funds to closing to cover that amount, but it is not required. And you're like, well, why on earth would they do that? There are some contracts where it is a very short closing, 7 to 10 day close. And it's like, okay, the seller says, I'll take that risk. I'll just take my house off the market, my property off the market for that short of a time frame and go to closing. If not, I'll just go back on the, if the buyer doesn't close, I just go back on the market and sell it to someone else. So you guys are correct. No. All right, now let's talk a little bit more about the closing attorney. In the GAR contract package, it states that the buyer, well, in both of them, the closing attorney represents the lender. However, in the GAR contract package, it states right here, paragraph B6, buyer shall have the right to select the closing attorney. And it goes on to say, so you guys are like, I know the argument, you listing agents. Well, if the seller's paying all the closing costs, the seller's paying the fee, the seller should choose. I'm just telling you guys what's in the purchase and sale agreement. If the seller and the buyer negotiate through that, then the buyer accepts whatever the closing attorney is. But I'm just telling you what's pre-printed in the GAR purchase and sale agreement. If there is no lender financing, no mortgage financing, then the GAR contract package says the closing attorney shall represent the buyer. In the RE forms, this is actually handled in the purchase and sale agreement itself. And it says under the closing attorney, paragraph 4, I'm back in the actual contract, the 5-page contract under the RE forms. It says the closing attorney shall be, you negotiate the closing attorney. If the closing attorney is unavailable or unacceptable to the buyer's lender, because the closing attorney represents the lender, then look here, fill in the blank. You negotiate. The buyer or the seller shall have the right to select a different closing attorney. Now, there's no verbiage in the RE forms about the attorney, quote unquote, representing one of the parties. Now, I'll caution you guys that are very familiar with the GAR and have your parties go binding under the GAR. This does not mean, don't let your public people think that all of a sudden, if there is a dispute, they've got legal representation. I don't know of any attorney that is going to represent the public in any kind of dispute without some sort of payment. So it doesn't mean that they represent the buyer if there's a dispute. They don't have attorney legal representation should there be an issue. What this means is when you go to closing, the closing attorney gets what we call a package from the lender, which is a set of instructions regarding how the closing attorney is to prepare the closing documents. Now, obviously, they close them with respect to the purchase and sale agreement, but they also get other instructions from the lender because that is the party that they represent at closing. So if there's no lender, the closing attorneys are not getting this package or set of instructions from a lender. So in essence, what this means, very loosely interpreted, is the closing attorney shall prepare the closing documents with respect to the buyer's position in this contract. That's what it means when it says represent the buyer. It doesn't, again, it doesn't mean that if there's a dispute over anything in the contract that the closing attorney, that the buyer has their own legal representation. All right. Just went over that. All right. Disbursement of earnest money. So basically, once the earnest money is in the holder's trust account, there are a limited, very specific number of ways the closing attorney can come out, the earnest money can come out of that trust account. If the parties never agree to a contract, if there's written agreement on the quote unquote release portion of a TNR, directing the holder how to disperse the funds, so forth and so on. All of that is the same in both. There are just a couple of differences if in between the GAR and the RE. In the GAR contract package, where it talks about the disbursement of the earnest money, the GAR contract package states that if the earnest money is going to be dispersed to the seller and those funds are over $600, before the holder disperses those funds to the seller, the holder may require the seller to sign a W-9 form, meaning they're also going to get a 1099 at the end of the year to pay taxes on that money. That verbiage is not included in the RE forms where it talks about, and this is in the standard terms, hang on. Here's where it talks about the disbursement of the earnest money. It doesn't have anything in there about requiring a W-9 from the seller if the seller gets it. Now, the other things is, again, in both GAR and RE, if the contract terminates and the parties do not agree in writing on the release portion of a 10-day, on the release portion of a termination and release, then the holder has a couple of options. This is in both of them. One of them is we can do what we call the 10-day letter, meaning the holder interprets the contract, figures out why it failed to close, and then sends notice to the parties how they're going to disperse those funds. They have to wait 10 days for the party not getting the funds to make a contractual written objection. And then they disperse the funds. Or the holder may interplead those funds into a court and let a judge decide. That happens if the earnest money is too much money, or if there is a gray issue and it brings into into consideration some legal issues, and your holders, your brokers typically are not closing attorneys. So we do have the option of interpleading it into a court. If it does get interpled into a court, guess what? The holder, that doesn't happen for free. The holder gets to take their fees, their attorney's costs and their fees out of the earnest money. And then whatever's left gets awarded to the winner, and the loser may have to pay the winner's legal fees in an interpleader case over earnest money. Again, that's in both. The one noted difference in the GAR contract package, and let me show you guys this. If the closing attorney, now I'm on F510, closing attorney acting as holder of earnest money. If the closing attorney is the holder of the earnest money and it is an all cash transaction, no lender involved, if the parties do not agree on the release portion of a T&R, how the closing attorney is to disperse those funds, the closing attorney does not have the option of interpreting the contract and making a decision. In an all cash transaction where the closing attorney is representing the buyer or the seller, the closing attorney can hold the earnest money, blah, blah, blah. But in the event of a dispute between the parties regarding the disbursement of funds, the closing attorney shall not disperse the funds based on reasonable interpretation. Instead, and notwithstanding any provision to the contrary, in an all-cash transaction, the only remedy available to the closing attorney to resolve the dispute shall be to interplead the funds into a court. So it is going to cost one of the parties money, and the earnest money that does get awarded to the winning party is going to be less than they put in, because again, the closing attorney can take their legal fees and court fees out of that earnest money if they have to interplead it. All cash dispute has to go to court. All right. Utilities. In the GAR contract package, it specifically states in paragraph B8A that the seller is required to turn the utilities on and keep them on from binding agreement date through closing. In the RE Forms contract package, it states you have a place to fill in the blank and to negotiate. Buyer or seller shall make all required utilities operational. So the parties get to negotiate. Generally speaking, it's the seller, but sometimes there is a vacant house with utilities not on, and the buyer is like, you know what, I'll pay to turn the utilities on so I can have my inspections done and appraisal done. I'm not going to wait on the seller to get around to it. All right, under those same inspection clauses, under the GAR contract, it does say that the buyer has the right to inspect the property, and the buyer may enter the property from binding through closing, and they have a duty to inspect the neighborhood. Under the RE forms, it says duty to inspect the neighborhood, buyer may enter binding through closing. So in essence, that is the same. What I want to bring to your attention though is something that is brand new in the GAR contract package in 2021. It had always said, I'm under GAR, purchase and sale now. It has always said that upon prior notice, the seller, buyer, and or buyer's representative shall have the right to enter the property at buyer's expense in reasonable times, including immediately prior to closing, i.e. for a walkthrough, to inspect, examine, test, appraise, survey the property. What I have underlined in red is brand new for 2021. The right to enter shall include the time period after the end of any due diligence period to, among other things and without limitation, meet contractors and vendors, measure for renovations, and confirm that any agreed upon repairs have been made and the property otherwise remains in the same condition. And there's where it talks about the utilities. So in essence, it had already said that the seller grants the buyer the right to come check out the property at immediate times. This is brand new for 2021. And the intent is, again, to be able to check it out after due diligence period. I think what's a little, what some sellers are taking a look at is to meet vendors there to measure for renovations. Come on, there's still somebody potentially living there. So just want to bring to your attention that new verbiage for 2021. And in the RE forms, it is under this section, under this one. It's again under the, no, it's right here. Sorry. It does say that buyer has the right and obligation with reasonable notice to the seller to inspect the property, limited to blah, 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 at any time and from time to time after the date of the acceptance, which is binding, and through closing. So in essence, that's the same. It's just that GAR kind of put in measure for renovations. That's a little bit interesting. All right. If there is damage from any inspection, again, they are both very similar in that they hold the broker harmless and the buyers to repair any damage caused by any inspections. Same thing in the RE form. Okay, contingencies. Let me see how much more we have to go on this. Okay, we're going to keep going until we finish the purchase and sale, and then we'll take a break. Contingencies. In the GAR contract package, there is only one built-in contingency, and that is the due diligence period. And basically, a due diligence period is defined as the seller granting the buyer the right to terminate the contract for any or no reason. Here we go. Property sold as is unless this agreement is subject to due diligence. Due diligence is basically the right for the seller to, the right for the buyer to terminate a contract for any or no reason, and to do so within that time frame by sending notice to the seller within that time frame under no penalty. In the RE Forms contract, there are 3 built-in contingencies. So I'm back on the RE Forms now. This is the purchase and sale agreement, and 3 built-in contingencies. One is the buyer's general right to terminate, which is the same thing as due diligence period. Again, seller grants the buyer the right to terminate this agreement for any or no reason and get their earnest money back if they do so and send notice blank days from binding agreement date. However, in the RE form purchase and sale agreement in and of itself, there was also built in an appraisal contingency and a financing contingency. And here's where the time frames are for that. What happens if the property doesn't appraise for sale price? Well, that's all explained on the standard terms. Financing contingency. What if the buyer doesn't get financing? How can they terminate? Under what terms? So forth and so on, time frames. That again is all spelled out in these standard terms. Again, why you guys really need to print these standard terms out and attach them to your contract. So those are 3 built-in contingencies into the RE forms. In GAR, you just have the due diligence. So if the buyer, if you go binding under the RE forms and the buyer is getting a conventional loan, no other exhibits are required for financing unless the buyer is getting an FHA insured loan or a VA insured loan. And it tells you here, if the buyer chooses FHA or VA, you must add an FHA or VA exhibit. If the buyer's just getting conventional financing, all you need is this purchase and sale agreement and the standard terms. Repairs. How are repairs addressed in the contracts? Both of them say that they must be done in a good and workmanlike manner. The GAR contract package has pre-printed that they must be completed prior to closing, and the RE Forms contract package states that they must be completed 3 days prior to closing. Now, if you you know, there are many agents and buyers and sellers that address repairs even furthermore in a special stipulation. I'm just going over what's pre-printed in the contract. In the RE, do you have to include exhibits for financing and appraisal? No, absolutely not. That's what I just pointed out. In the RE contract, they're built in. You don't need any exhibits. Now you have to check the box, but appraisal contingency. If you check the box, this contract is contingent upon the property appraising for sale price. Financing contingency. This contract is contingent upon the buyer getting financing from a mortgage lender under these terms. Buyer's general right to terminate. You do not need any additional forms if they're binding under the RE other than unless the buyer's getting an FHA or VA insured loan. So what happens if it doesn't appraise? Again, close your eyes so you don't get seasick. Here under the standard terms, here's where it talks about what happens if it doesn't appraise. Well, here's what has to happen in the timeframes and the notices. What happens if the buyer doesn't get their financing contingency? Here's what has to happen with notices and denial letters and the seller's remedies and repercussions. So you don't need any additional documents other than the purchase and sale agreement for an appraisal and a financing contingency binding under the RE forms. If these boxes are not checked, then it is an all cash deal. All right. Now, under this section, under the broker's agent disclaimer and limits of authority, this is the protection paragraph for you guys as affiliated licensees and your brokers. So under the GAR contract, it's all under this paragraph under brokerage relationships in this transaction. And basically it says the disclaimer paragraph states that the buyer and the seller have not relied on any advice or representations of the broker, that basically it is their responsibility to check out the property for termites, utility bills, septic tank, zoning, methamphetamine, mold, asbestos, lead-based paint, blah, 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 so forth and so on. It does say that the broker also has no duty to inspect the property or advise the buyer and the seller on any of these matters. New for 2021, GAR has added in that it is also the buyer's responsibility to check out that, guess what, this property may have a propensity to flood. You need to check out if it's in a flood zone and if you're going to need additional flood insurance for your hazard insurance. Even though the seller has not had to pay it, the flood zones change or a lender may require that. Also in the GAR contract, under this same paragraph, it states that if the broker / agent has written any special stipulations, the party that the special stipulation was written for confirms that it reflects their wishes. And this next section says they adopt the special stipulation as the original work of the party, meaning the broker, meaning GAR didn't write it, don't sue GAR. And it goes on to say that the buyer acknowledges that if the broker answers the buyer's question with respect to the contract, that the agent / broker is answering based on information provided by the seller. There is a ton of protection information in this paragraph for you guys as agents and your brokers. In the RE forms paragraph, it goes on further, I can't find it right now, about the limits of your liability. Let's see where that is. Broker's limits on of authority. Broker owes no duty outside of what is described in a buyer brokerage agreement or a listing agreement. In the RE forms contract package, again, under the standard terms, it is also spelled out there. I'm back on the RE contract under the standard terms, paragraph 8. Again, it's under the same paragraph under the brokerage paragraph. And it does say all parties represented by a broker acknowledge no broker in this transaction shall owe any duty to buyer or seller, greater than what is set forth in their brokerage engagement, which is a buyer brokerage agreement or listing agreement, and per Beretta law. And it goes on to say that a broker is not an expert in matters related to the condition of the property. In other words, buyer, it is your responsibility to check out the property, and the parties do not rely on any advice given by the broker or agent. And if there is liability found to exist, liability is limited to the amount of commission actually received in the contract. And that same verbiage is actually in GAR, and it limits it to $100. Okay, moving along. Notice. You guys, again, the purpose of this class is just to point out comparison and contrast between the two contract packages. We have a whole additional 3-hour CE class on the GAR contract called 2021 GAR Contract Dissection, and a whole 3-hour CE class on the RE Forms called 2021 RE Forms Contract Dissection. So this isn't going over, we would be here for 9 hours. So I'm kind of glossing over the differences because that's the purpose of this class, not going over everything. Okay, in the section under notices, in the GAR, it's under paragraph C1, and in the RE Forms, it is under RE1, which is the standard terms, under paragraph 11. Oops. So in the RE Forms, it is all spelled out here under the notice section. And in both sets of contracts, it states that it gives the forms of notice, which are the same. And it says that the receiver, that receipt of notice is deemed, one of the parties is deemed to have received notice when the sender can prove they sent it. So if let's say I'm sending a TNR, and let's say I send the email with the signed termination notice attached at 11:58 p.m. on February 23rd. But the other side doesn't, they're sleeping or they're doing something else other than at their computer. So they don't actually get the email and receive it and open it until February 24th. It doesn't matter. It is deemed received by that other party when the sender can prove they sent it. When I can prove I sent the email with that attachment, that's when it is deemed received. That is the same for both contracts. In the RE Forms, that is new verbiage as of 2019. Now, also in that notices section, it says that notices must be sent to the address or email or fax number that is printed on the signature page of your contract, or subsequently changed with notice, and it describes how you would change that. That is the same for both contracts. Now, moving along to default. If one of the parties defaults on the contract under paragraph C2 under default, this is where it talks about the remedies of the seller if the buyer defaults, remedies of the buyer if the seller defaults, rights of the broker if either buyer or seller default, and attorney's fees. And basically attorney's fees says loser has to pay the winner's attorney's fees. And for default in the RE Forms, it is in the standard terms, paragraph 10. So we go up here a little bit. Under default, if the buyer defaults, what is the seller entitled to? If the seller defaults, what is the buyer entitled to? And brokers, what are they entitled to if either party defaults? Now, these are the same. If the buyer defaults, the seller's sole remedy is to retain the earnest money's liquidated damages. They can't sue them. They can't sue them for specific damages. They can't sue them for time off the market. They can't sue them for moving costs. They can't sue them for the hotel bill that they're staying at. it's just earnest money. If the seller defaults, then the buyer may terminate the contract and get their earnest money back and go about their life and find another house. Or the buyer can sue the seller for specific performance. And what that means is that you would basically, a judge would make the seller follow through on the contract, not for free, but they have to follow through on the contract. There's a lot involved with that. You'd have to file, the buyer would have to file a lis pendens to put people on notice that that property, that seller is being sued, in order to prevent that seller from selling it to someone else. Same thing in the RE forms is the buyer, if the seller, back up here, if the seller defaults, the buyer can get their earnest money back. If the seller defaults, again, buyer can get their earnest, I'm sorry. If the buyer defaults under the RE forms, the seller gets the earnest money as liquidated damages. That's it. They can't sue them for anything. And if the seller defaults, same thing, buyer can get their earnest money back and go on and find another contract, or can sue for specific performance. If you're suing, if a buyer is going to sue for specific performance, they don't get their earnest money back because it depends on what the judge is going to rule. Now, the reason I point this out, even though they're the same, is under the RE forms, this was just changed in 2019. It used to say under the RE forms that the parties could sue the defaulting party any remedy under the law, but they took that out in 2019. And remedy for the broker, if either party defaults, is the broker can pursue commission that would have been earned. All right, we're almost done with the purchase and sale, and then we'll take a break, so hang in there. The condition of the property, the GAR contract under paragraph C3, under this paragraph, it says that basically at closing, the property is to be in substantially the same condition as it was as of the offer date, and clean and free of trash and debris and personal property not identified as remaining. In the RE forms, it says that the property as of the acceptance date or binding date shall be in the same condition, normal wear and tear accepted, broom clean, all garbage, debris, and personal property removed. So they're similar, but the difference is substantially the same condition versus same condition, normal wear and tear. GAR used to have this verbiage and they changed it. Let me tell you why they changed it. There was apparently a lawsuit, this is several years ago now. Buyer and a seller go under contract, 20-year-old home. The buyer has it inspected, air conditioner is working. They do a final walkthrough and the air conditioner, which was original to the house, is no longer working. They don't close, they go to court, and the contract, the GAR contract, used to say property at closing shall be the same thing it was at binding, normal wear and tear accepted. The judge ruled that the buyer defaulted by not closing and were obligated to close even though that AC was no longer working, because it's pretty normal for a 20-year-old air conditioning unit to poop out. So that did meet the terms of the contract, normal wear and tear accepted. At that point, GAR changed the contract to now say that at closing, the property needs to be in substantially the same condition as it was as of offer date. That got changed last year. A non-working HVAC unit is not substantially the same as a working HVAC unit. So that is a pretty interesting difference if you are selling, especially an older home. That's a distinction, and that's why GAR changed that. Moving along to where it talks about damage to the property. This is basically if the property was destroyed by fire or a weather event or, you know, something along those lines. And in the GAR contract, basically it says they can either terminate, or the seller has 1 year to restore the property, and then the contract must close within that year or within 7 days if it takes sooner than that for the seller to get it back into saleable condition to restore the property. Under the RE forms, the buyer may terminate, or the buyer can go ahead and close as long as the seller transfers any and all insurance proceeds to the buyer. Under termination of contract, in the GAR contract, it specifically says that, let me see where it is again, C4E. It says that if a party is going to terminate, it must be done so in writing and signed by the parties. In the RE Forms contract package, it doesn't have any specific separate paragraph regarding termination. It just defines termination rights with respect to do so within a given contingency. For example, it talks about notices, timeframes, and in writing to terminate under buyer's right to terminate under that paragraph. It talks about in writing notices and timeframes and signatures if a buyer is terminating under a financing contingency under that section. It's not a whole separate section. It's contained within the provision to do so. Now, let's look at assignment of contract. In the GAR contract package, under this same paragraph, it specifically states this agreement may not be assigned by the buyer. In other words, that's a big strategy that a lot of buyers are using nowadays. They will go under contract with the seller. They have no intention of living in that property. They find another buyer and assign the contract to another buyer. The GAR purchase and sale agreement is not assignable in and of itself without the written approval of the seller, and the seller does not have to agree. So that is written here in the GAR purchase and sale. In the RE forms, assignment of the contract is not referenced at all. And then extension of deadlines. In the GAR contract package, under extension of deadlines, it basically says no deadline can be extended if it falls on a Saturday, Sunday, or federal holiday, except for closing. The RE forms contract package only references extension of deadlines as they pertain to new construction. And that has to do with not getting materials or weather-related issues, so forth and so on. So in other words, if you're binding under the GAR contract package and you didn't look at a calendar and you have a closing date scheduled for, let's say it was scheduled for President's Day, and that is a federal holiday, it automatically gets extended to the next business day. If, however, your due diligence ends on a Sunday, your due diligence ends on a Sunday, or any other contingency time frame, if it falls on a weekend or a federal holiday, that's where it ends. Again, the RE forms contract package does not address that. And it goes on to say the GAR contract package, no party is required to use the specific GAR contract. And in 2021, GAR added that the courts may rule against the contract, whatever's in the contract, despite the intent of the parties, brand new in 2021, and that you must be an authorized user of the GAR forms. Nothing is referenced in the RE forms about their use. Statute of limitations, GAR has a paragraph that there is a 2-year statute of limitations to sue the other party if from the date of the claim. Statute of limitations is not referenced in the RE forms, but I believe by law there may be a 2-year date. You have to check with an attorney. All right, survival of closing. This is, okay, we're almost done. Survival of closing. This is a huge difference between the contract packages. In the GAR contract package, it is in this section, and it states specifically what survives closing. In the RE forms contract package, it states, let me start with the RE. The RE contract package states, the provisions of the contract shall survive closing, meaning anything and everything that the buyer and the seller agree to survive the closing. In the GAR contract package, there are only 6 things that survive closing. Commission, yay, any warranty of title, all written representations of the seller regarding the property or the neighborhood, and that's verbiage is new for 2021 where it says written and includes neighborhood. If the property has been condemned, that survives. And the obligations of the parties regarding ad valorem real property taxes, that's new for 2021. And any obligations which the parties herein agree shall survive the closing, survive the closing. So if you're binding under the GAR contract, you need to remember this magic phrase, all the provisions of the contract, this provision shall survive closing, because that ties it in to the parties agreeing. Again, very, very limited what survives the closing. Nothing about repairs, nothing about home warranties, so forth and so on. In the RE, everything survives closing. Binding contract, it is the same definition, just different terms. GAR refers to that as a binding agreement. The RE forms refers to a binding agreement as an accepted contract. Under days, same thing, calendar days. GAR uses the word business days to mean Monday through Friday, no federal holidays. RE forms uses the term banking days. There is a cyber fraud disclaimer in both. Under GAR, there is a limitation of liability should one of the parties be a victim of cyber fraud, and the broker's liability is limited to $100. Under the RE forms, they don't have, that's not addressed with any dollar amount. Under the broker agent liability, I already talked about this, not greater than the amount of commission or not greater than $100 if there's no commission. And in the RE forms, limited to the amount of commission. Technology and privacy. The RE forms has a disclaimer against any recordings of the buyer in the home. Actually, I need to add that here. In 2021, they have just added that to GAR, that a buyer or a buyer's agent may record video or audio or take pictures inside a buyer's home, even though they're not supposed to. And there is no liability. It's just an admonition to the seller that that could occur. And again, that is brand new verbiage in 2021. Whew. All right. That was a lot. That was just the purchase and sale, the differences. So let's do this. Let's take a break. I've got 11:13. Let's come back at 11:30. And we go till 12:30, and I will go through the other differences and similarities, main differences and similarities between the GAR and the RE contract packages. But in the meantime, take a break. When you come back from the break, once again, please type in your name, email address, and real estate license number when you get back from the break. You only have to do it once. At the beginning, now when you come back from the break, and then before you leave. Come back at 11:30, and I'm going to go take a break as well. So I'll answer questions when I get back, and I'll answer questions at the end. But we'll see you guys at 11:30. All right. So continuing on after the break, we have just covered the main differences between the GAR, Georgia Association of REALTORS contract, purchase and sale agreement, and the RE forms contract, as well as standard terms. We are moving along to loan contingencies. So we are going to continue to move along to cover all the other differences, comparison, and contrast between the GAR contract package and the RE contract package. So in the GAR contract package, if it is no loan involved, no loan contingency, just all cash, GAR does have a separate exhibit that is an all cash exhibit. If you are representing a buyer, you're not required to use it. If you do not include any other financing contingency, it is all cash anyway. It's just that a seller might want to see, let me show you this. A seller might want to see proof of funds within so many days, so forth and so on. So this would be the form if you're using GAR for all cash, or if you are getting if your buyer is getting a hard money loan, or again, you don't need to use this. It would just be a cash contract without any exhibit. Under the RE Forms contract, under the purchase and sale, remember, we stated that the contingencies, the financing contingency is built in. I'm back under the purchase and sale agreement under the RE Forms. The financing contingency is built into the contract. So if you do not check that box, guess what? It's an all cash contract. So all you have to do is simply not check that box under the RE Forms. All right. Under the financing contingencies themselves, in the GAR contract, if the buyer is making their purchase contingent upon them getting financed through an institutional, third-party institutional lender, you must use a separate exhibit for that. And GAR has F404 for the conventional financing, 407 is the FHA financing exhibit, and F10, 410 is the VA contingency exhibit. Again, in the RE Forms, if it's conventional, you just check that box here in the purchase and sale agreement. If it is FHA or VA, you will need the FHA or the VA contingency exhibit. Now, what are the terms and timeframes of the loan contingency exhibits? In the GAR contract package, all of that is spelled out on the exhibit itself. So for example, here's the conventional loan contingency exhibit. There are the terms. It has a whole bunch more in here that we cover in the GAR contract package, GAR contract dissection class itself. But here's the time frame. Under this section, paragraph 5, financing contingency, buyer shall have X number of days from binding agreement to determine if they have the ability to obtain the loan described above. In the RE Forms contract package, the time frame is in, look where we are. We're actually in the actual contract. We are on page 2 of the actual contract in and of itself under the RE Forms. And for the financing contingency, the time frame is the buyer, this contingency shall expire at 11:59 p.m. on the day that is X number of days after the acceptance date. So there's the time frame. Now, and the terms under the RE, here's where you fill in the terms, the amount of the loan, the interest rate, the number of years, so forth and so on. Now, again, in the RE Forms, if you are getting FHA or VA, if you're getting conventional, this is all you need. If you are getting FHA or VA, close your eyes so you don't get seasick. There is a separate, okay, you can open your eyes now. FHA loan contingency exhibit. There's no time frame on this exhibit because the time frame is in the purchase and sale agreement, but the rest of the terms are spelled out on this exhibit for FHA. And same thing for VA under the RE Forms. Now, what if a buyer is going to terminate because they cannot get their financing? Well, again, those are all spelled out in the RE Forms. It's spelled out in the standard terms. In the GAR, it's spelled out on the loan contingency exhibit itself. The biggest differences between those is that if the parties are binding under GAR, they must send the and they're going to terminate under financing because they can't get finance. They have to send that termination notice prior to whatever that time frame is, the contingency time frame. And then they have 7 days after they send the notice of termination to provide proof of it with a loan denial letter. If the parties are binding under the RE Forms contract, all of this is spelled out in the standard terms. If the party is going to terminate prior to the end of their financing contingency time frame and to protect their earnest money, they still have to prove it, but they must send the loan denial letter simultaneously with the termination notice. Now, that loan denial letter, it's very specific what must be in there, why the loan is denied, if the buyer's earnest money is to be protected or not. And those are very, very, very similar in the GAR and the RE forms. The only difference is GAR last year added the word solely to those specifications. Now, what happens if we go through financing and there's a few differences in these financing exhibits. In the GAR contract package, we go through financing. This financing time frame ends and the buyer does not terminate. This is where it's spelled out about the loan denial letter, so forth and so on. If the buyer does not terminate within the financing contingency time frame, the seller then has the right to request evidence of the buyer's ability to close. In other words, the seller can ask for a loan commitment letter from the lender, and if not provided, the seller then has the right to terminate. Again, there's time frames and notices, and those are all spelled out there. In the RE forms contract, it only talks about termination rights of a seller if the underwriting criteria is going to end up costing a seller more than was agreed upon in the contract. And we talked about that with relation in respect to, I pointed that out when we were talking about extension of contract. But if it talks about repair costs exceed the other way a seller can terminate after the financing contingency is in the if the costs under the, I'm sorry, getting a little tongue tied here, in the FHA and the VA loan, and this is true in both of them. It talks about under the repairs. Let me find where it is. Okay, that's conventional. Hang on. This is the FHA loan exhibit under GAR, and it talks about repairs, and you negotiate up front how much the seller is willing to, or buyer or seller are willing to pay for repairs that are mandated in order to get their FHA commitment. If the actual costs exceed the amount listed below, this is how the buyer and seller work through that, and the seller does have termination rights there. And the same thing in the RE forms FHA exhibit, it does also have seller termination rights if the repair costs are in excess of amount of what is negotiated. So that's similar between both of them. Now let's look at appraisal contingency timeframes. Again, in the GAR package, the appraisal contingency timeframes are included in the actual loan contingency exhibits. In the RE forms, the appraisal contingency timeframes are included in the purchase and sale agreement for a conventional loan. And both GAR and RE forms, this is the same in both of them. If a buyer is getting if the buyer is getting an FHA insured loan or a VA loan, those appraisal contingencies go through day of closing, regardless if you're binding under GAR or RE. If you write a contract under the RE forms, can I use the GAR forms for the exhibits? No, not really, because it depends on the RE. It depends. If it's a conventional loan on the RE form, there is no exhibit. It's in the purchase and sale. If you're binding under the RE forms and the buyer is getting an FHA or a VA insured loan, I'm not sure there is an FHA and VA loan contingency exhibit in the RE forms package. So I'm not sure why you would want to use the GAR exhibits. Yes, you can mix the forms. It's not that you can't mix the forms. You just have to look at what the forms say. For example, if the buyer and seller are binding under the RE forms contract package, we already discussed there's no unilateral right to terminate. There is a GAR amendment to extend the closing and possession date. In the GAR amendment, it has a paragraph, it has a sentence that references, shall the 8-day unilateral right to extend still be intact or not? Well, that doesn't make sense because there is no unilateral right to extend under the RE. So you can mix and match the forms, but you have to read through them and make sure that it is something that is applicable to the main purchase and sale agreement that the parties are binding under. Okay, another huge difference between the GAR and the RE forms. If the buyer's getting a conventional loan and the appraisal comes in lower than the contract sale price, when you are binding under GAR, let me go back up here to the conventional loan in GAR. This is all spelled out under this appraisal contingency paragraph 11. Conventional loan, binding under GAR, low appraisal, the buyer absolutely must give the seller the opportunity to sell it to them for the appraised price. This is all spelled out here. The buyer must send over the amendment to the sale price. Under the RE forms, conventional loan, appraisal comes in lower than contract sale price, the buyer may terminate at their sole discretion. Now, they can send over an amendment to the seller to agree to sell it at the appraised price, but they have immediate termination rights. That's a big difference between the two contract packages for a conventional loan. Both contract packages, failure to appraise and they're binding under, they're getting an FHA insured loan, either party may, the buyer may terminate with a low appraisal. They don't have to give the seller the right to sell it, the opportunity to sell it for the appraisal price, and they may do it through day of closing. That is true for FHA and VA, regardless if you are binding under GAR or RE. And then again, various costs associated with an FHA, VA, or USDA loan. We've just discussed that already. And under the VA loan exhibit, very similar in terms of a seller must provide. In GAR, it specifically spells out on the VA loan exhibit that the seller must provide a termite clearance letter that is dated no later than 90 days prior to close. It has other verbiage in there about repairs that was new last year. In the RE forms, it doesn't specifically identify a termite clearance letter, but you as an agent know that if a buyer's getting a VA insured loan, the seller must provide a termite clearance letter. And in the RE forms under the VA loan exhibit, it just says seller to pay costs associated with the VA loan that the buyer is not allowed to pay. So it's a little bit more vague. Does the seller have to agree to reduce the sale price if it doesn't appraise? Absolutely not. It's an amendment. They don't have to agree to it. They can say, sorry, buyer, nope. You can terminate or you can bring cash for the difference. If you terminate, I'll go on to my next buyer. Or if you bring cash for the difference, we'll go to closing. All right. If an amendment is presented to either party, nobody has to sign it. You don't have to agree to an amendment after you are binding. Okay, moving along. Counteroffer form. In 2021, there is new verbiage in close your eyes so you don't get seasick. Okay. Well, darn it. I have the wrong one. This is the RE form. Let's see if I mixed them up. Well, shoot. All right, I have to redo this package. In the GAR contract package, there is new verbiage as of 2021 that in essence says, once a party initiates a counteroffer, everything else is off the table. The original offer, even if the time limit has not expired, Once a party initiates a counteroffer, you cannot go back and sign an unexpired offer or previous counteroffer. The RE forms does not have verbiage to that effect, but my understanding is that legally, once a counteroffer is initiated, everything else is off the table, even if the time limit had not expired. Again, it's just brand new verbiage in GAR on that counteroffer form in 2021. Seller's disclosure form. In the GAR contract package, there is no I don't know. It's just yes or no. And in the RE forms contract package, it does have yes, no, or unknown. One of the biggest differences, however, in the seller's disclosure form, in the GAR contract package, there is this last paragraph where it is called Fixtures Checklist. And this is where a seller indicates what items are staying with the property. Items on the checklist below that are checked shall remain with the property. And there's a whole list of items here. In the RE forms contract package, there is a list that looks a little bit similar. It talks about security alarm system, smoke detectors, sprinklers, oven, range, refrigerator, so forth and so on. But look at what the seller fills out here. Have there been or are there any known material defects of any of the following? Yes, no, unknown, or not applicable. There's no provision for a seller and to indicate what the seller is removing from the property at closing, which assumes that all of these items are staying with the property at closing. If you go binding under the RE forms, you may want to consider using a bill of sale for those things such as refrigerators, so forth and so on. Just know that's here. There is a bill of sale in the GAR forms too, but very different in when you have these items. This has what is staying with the property. Now, in 2021, there is a brand new GAR form that is called the Seller's Disclosure of Latent Defects and Fixtures Checklist. Brand new in 2021. This is only a 2-page form. And in essence, this is designed for sellers that do not live in the house. For example, a seller that has inherited the house, a seller that is an LLC, a bank that has taken the property back by foreclosure, an investor, though I think there are many investors that know more about the houses than some owner occupants. But nevertheless, regardless if a person has lived in a house or not, they are still bound by Georgia law to disclose any latent material defects. So GAR this year has come up with this form, Seller's Disclosure of Latent Defects and Fixtures Checklist, to help that seller identify this, because many sellers did not want to fill out this complete 7-page property disclosure statement, especially if they had never lived in the home. And again, GAR came up with this form to use in 2021. Now, if you do have a seller that is an owner occupant, they too can use it. But the design of this is really for someone who's never lived in the house. So this would be an example where you could mix forms. Let's say the buyer and seller are binding under the RE forms, purchase and sale agreement and standard terms. But the seller might want to use this brand new form rather than the full-blown seller's property disclosure statement. So that would be an example where, yes, you absolutely may mix the forms. And that would be an appropriate use of the forms. I get a little note that somebody is raising their hand, but I don't see what that is. So just please type your question in the chat box. All right. All right. Community Association Exhibit. Does the seller have to complete the form? Okay. So in the actual listing agreement, if a seller signs a seller's brokerage agreement with your broker under GAR or RE forms, it does have in there that the seller does agree to complete the seller's property disclosure form. So if the seller is not going to fill out a seller's property disclosure form, then you must address that as a special stipulation in your listing agreement. Legally, is the seller required to fill that out? Absolutely not. Legally, however, a seller and you as a real estate licensee, by virtue of holding a real estate license issued to you by the state of Georgia, you are required to disclose latent material defects of the property. But you can do that on any form. If you do not have any knowledge of latent material defects, you do not have to fill out any sort of seller's property disclosure form, but that is included in the listing agreement. So you need to address it in the listing agreement if a seller does not want to fill that form out. Community Association Disclosure. In essence, these two are the same. For you agents using the GAR, primarily the GAR contract package, this form was completely redone in 2021. And when I say completely, I mean in terms of the format, the fonts, the ordering of the topics. Content-wise, it was not changed that drastically. In the RE Forms contract package, it was changed pretty drastically in 2019, but it has not changed since 2019. In essence, what they both say, again, we cover both of these very specifically in the GAR CE class and in the RE Forms contract class. In essence, what they say is the duty is on the seller to disclose all the fees related to that property being part of an association, a homeowners association, and if managed by a management company, the management company. All fees to transfer, initiation fees, clearance fees, special assessments that have already passed, special assessments under consideration, special assessments out into the future, so forth and so on. And it's not that we're trying to punish any sellers out there. It's just that a lot of these associations, the only one they will disclose these fees to are the sellers. They will not disclose a lot of these fees to the buyers or to either agent. So it is incumbent upon the sellers because that's the only way to disclose those fees. So because that seems to be the case with a lot of these HOAs and management companies, these forms, both under GAR and RE, generally say that any fees that are not disclosed by the seller or any increases in the fees will be the responsibility of the seller to pay at closing, even if it is a buyer-related fee. For example, even if it is an initiation fee to join that HOA, which is typically a buyer benefit fee, if it was not disclosed or under disclosed by the seller, at closing, the seller is going to have to pay it. And again, that's in essence what they both are. The RE form prior to 2019 put the burden on the buyer and said, look, buyer, Georgia's a caveat emptor state. It's up to you to find it out and figure it out. But because of what's happening, especially in Metro Atlanta area, the HOAs and the management companies just will not communicate with anyone other than the seller. It's very, very difficult for a buyer to actually do that within their due diligence time frame because they just cannot get that information. All right, moving along. Amendment during the due diligence period or buyer's right to terminate period. There's a lot of differences between these two forms. In the GAR contract package, it's form F704. And in the RE form, and it's called, well, let me just show you. Amendment to address concerns with the property. In the RE forms contract package, it is form RE 262, and it is amendment during buyer's right to terminate period. So this is the amendment you use during the same time frame, due diligence, buyer's right to terminate. The main differences are, and this is where a buyer asks the seller to address certain concerns with the property. Here are the main differences. Under the GAR Amendment to address concerns with the property, it has verbiage. This was brand new in 2020, May, actually, just mid-year. No, actually, August of 2019 is when this paragraph came in. It says this amendment is intended to set forth the agreement between the parties relative to concerns raised by the buyer during the due diligence period. If this amendment does not become effective during the due diligence period, it shall become null and void and of no legal force in effect. How would this amendment become effective? How is it evidence that it's effective? Type it in the chat. How would you know when this amendment becomes effective? GAR's using a little bit more legalese than they need to. Correct. All parties must sign. All parties agree. In other words, you need both buyer and seller signatures on this amendment before the expiration of the due diligence period in order for these obligations to be part of the contract. So if a buyer asks the seller to fix A, B, C, and D, and the due diligence period comes and goes, and then after that, you get it back signed by the seller, this amendment acts as if it does not exist. The seller is not obligated to perform those repairs or address those issues. So if you are going to go past your due diligence period and the buyer and the seller do agree on repair issues or anything that the seller is going to address with the property, you would do that on a general amendment, not on this amendment, because this amendment, if it is not signed before the end of due diligence, there are no obligations of the parties it's null and void and is not part of the contract. That verbiage is not included on the RE amendment to address concerns. Another big difference, you see this shall or shall not checkbox. On the RE forms, you see a shall or shall not checkbox. These are completely different issues. On the GAR form, this says if buyer and a seller both sign this and agree before the end of due diligence period, then this shall, let's say if we mark shall, this shall terminate the due diligence period. So if you have a 10-day due diligence period and the buyer and the seller agree on this on day 5 after binding agreement date, that ends the due diligence period for the buyer, regardless of the 10 days on the purchase and sale agreement. The buyer's due diligence period just got shortened if this is marked shall. The shall or shall not on the RE forms amendment has to do with termination of the contract. So if you mark shall, this says this amendment shall act as a unilateral notice of termination if it's not accepted by the seller and sent back to the buyer before the end of the due diligence period. You as a buyer's agent, you're only going to mark shall if it is what I like to call a make it or break it issue. If the property needs a new roof, if the property needs if the foundation is all wonky and it needs a structural foundation engineer to prop it up so it doesn't fall. If it is a huge make it or break it issue, then you might want to actually mark shall, meaning if the seller doesn't agree to replace the roof or fix the structure or something like that, then this would terminate the contract on behalf of their buyer before the end of that time frame and protect their earnest money. If it's things like replacing some rotten wood around the windows and repainting to match, so forth and so on, things the buyer really doesn't want to pay for, but they don't want to terminate the contract, then you would mark shall not. Big differences in those. All right. Temporary occupancy agreement for the seller after closing. Oh, also I have on here this verbiage where it says this amendment shall or shall not act as unilateral notice of termination if not accepted by the seller and delivered back to the buyer prior to the end of due diligence period. GAR liked that so much, they have a special stipulation. It's special stipulation number 302 called Amendment to Address Concerns as Notice to Terminate. It's basically that exact verbiage that you can use in your GAR contract. Again, if it is a make it or break it issue, something big that the buyer just cannot afford the house, like I said, if it needs a new roof, so forth and so on. All right, temporary occupancy agreement. Big, huge difference in these. So under the GAR, this might be another situation where you might want to do the mixy-matchy. So this is the GAR temporary occupancy agreement for the seller after closing. And you have the offer date, the property address. This says the seller, so the seller says, look, I'll sell you my house, but I don't want to vacate the house day of closing because it might not close on time, so forth and so on. I want to stay in the house for a few days after closing. So the buyer says, okay, I will do that, but not without an agreement. Seller shall have the right to occupy the property for X number of days after the closing, hereinafter called temporary occupancy agreement. Seller shall vacate the property no later than by the temporary occupancy agreement. If they vacate the property sooner, they shall notify the buyer. And then it goes on and about possession and utilities and insurance and so forth and so on. Then we come down here in paragraph 10, we see a $sign. It says, if the seller does not timely vacate the property at the end of this temporary occupancy agreement, the seller shall be deemed what's called a tenant at sufferance and shall be unlawfully holding over and shall be subject to being evicted and shall pay the buyer a per day rent during the period in which the seller is holding over in the amount of X number of days per day after the end of the temporary occupancy. So this dollar amount is only after, let's say the buyer gives the seller 5 days to stay in the property, temporary occupancy. The end of that 5 days and the seller is not out. That is when this per diem kicks in. But good luck collecting it. If the seller hadn't moved out, the seller may not pay. So but this is the only dollar amount. This is great if you represent a seller because the seller gets to stay in the house that somebody else owns after closing. The RE Forms occupancy agreement for the seller after closing, looky here. It has the same information, date of occupancy for so many days, so forth and so on, condition of the property, maintenance of the property, utilities, repairs, insurance, so forth and so on. But look here, this is the biggest difference. Compensation. Under the RE Forms temporary occupancy for seller, it has a usage fee. The seller shall pay the buyer at closing, so they're going to get it because they're going to be together at the closing table, a usage fee in the amount of either a blank sum or blank per month. I would do a blank sum, beginning on such and such date and continuing thereafter on the blank day of each day, if that's going to be a per month. All payments shall be payable to the buyer at the following address. Again, that's if it's not a lump sum. Now, it also has a nope, doesn't have that. So this is great for a buyer. If I'm a buyer and I now own this home and I have agreed to allow the seller to stay in there, I'm going to want some compensation for giving them the privilege of staying in my home. So this is a compensation fee for that occupancy time frame. This is addressed in the RE Forms contract package, in the RE form, not in the GAR form. Now, both of them do say that you cannot use a temporary occupancy agreement for more than 60 days. If it's going to be for more than 60 days, you need an actual lease. And if you're going to have an actual lease, that may be an issue with the lender, because that would mean you as the buyer, your buyer is buying it as an investment property, not as an owner-occupant property. What is the downside of a temporary occupancy agreement? You absolutely need one. As a matter of fact, in the GAR contract package itself, it states back up here in the actual purchase and sale agreement, under the section where it talks about closing in possession. If possession is not at closing, if it is going to be X number of days after closing, this is the GAR purchase and sale, it says you need to attach a temporary occupancy agreement describing what that occupancy is. It has the same verbiage in the RE Forms contract package where under the RE Forms contract where it talks about possession being after closing. It says you need a temporary occupancy agreement. You need to describe what happens. What happens if there's damage? What happens regarding insurance? What happens, pets, so forth and so on. Because now the seller, guess what, guys? They no longer own the home. The buyer owns the home, so they are occupying somebody else's home. Let me find it again. So they're not considered a quote unquote tenant. Why would you not want, don't type this in because it's gonna be too much, but why would you not want a seller maintaining temporary occupancy to be a true tenant in Georgia? Both of them, it's just temporary occupancy. And this is the agreement between the buyer and the seller regarding surrounding the terms of that occupancy. The reason you don't want a true, you don't want that seller to be a true tenant is because that kicks in a whole additional body of laws. Now, it still might be difficult to get the seller out, but it kicks in a whole additional body of laws, all the Georgia landlord tenant laws, if it is a true lease and the seller is an actual tenant. You don't want the seller to be a tenant. It's just an agreement regarding temporary occupancy. But if the seller doesn't vacate, the seller is still called what we call a tenant at sufferance. That's just a legal term. It doesn't mean they're a tenant under an actual lease. But if they are a tenant at sufferance, the owner, the new buyer, who's the new owner, is still going to have to go through the eviction process, starting with a writ of dispossessory, so forth and so on. But it's just that this whole other body of laws, now again, a judge can change anything, but generally speaking, would not kick in, because in Georgia, our landlord tenant laws absolutely favor the tenant. All right, moving along. If the parties want to terminate a contract, under the GAR contract package, you have to do two things. You have to terminate a contract and you have to release the earnest money that is on hold. These are two separate contractual issues. GAR, however, handles both of these contractual issues on one form, and it is the F-522. This is the unilateral notice to terminate. Unilateral, we already said that's one. So you see an or. It can be terminated by the buyer or the seller. You only need one party's signatures to terminate. Once it's terminated, it is terminated. A separate contractual issue, however, is what happens to the earnest money that is on hold. Well, the buyer and the seller get to agree. They have to agree. That's why you have an and. You have an or and you have an and. You need both parties' signatures regarding the disbursement of the earnest money. And this is where you describe what happens there. They are two, however, separate contractual issues. You can have a termination and a disagreement as to the disbursement of the earnest money. That doesn't undo or delay the termination. Once it's terminated, it's terminated. Now, GAR in 2021 has a brand new form if the parties change their mind. But generally speaking, once it's terminated, it's terminated. So again, if there's a disagreement regarding the earnest money, the seller, it's still a terminated contract. So these are two completely separate issues. In the RE Forms contract package, these two separate contractual issues are handled on two separate forms because they're two separate issues. So in the RE Forms contract package, you have the notice to withdraw or terminate, and you would mark that that accepted contract with the acceptance date. And again, that's the word they use for binding agreement date. Here's the reason for termination. Again, it's unilateral. And so you need either the buyer or the seller. Don't get confused. It says both signed and printed. That means you need to sign it and print it. Then you have a separate form in the RE package, agreement to disperse trust funds. This is the release. This is where you describe who the holder is, how much the earnest money is, and how to disperse them. And you need both parties' signatures on this. It's called agreement. Agreement means both. You need two people to agree. Notice means one. Anytime you see notice, it's unilateral. Anytime you see agreement, you need both. Easy way to remember that. If you think back to your elementary school history and the beginning of the Revolutionary War, and you think about the old story that we were all taught, that Paul Revere was riding around on his horse, giving notice to the citizens of Boston. The British are coming, the British are coming. I want you to picture one man on one horse nailing the notice that the British are coming to the churches and the polls and all of that stuff. They were sending notice. One man, one horse, notice. I'm giving you notice. The British are coming. The British are coming. We're about to engage in war. Agreement, the way I want you to remember agreement is if you picture in your mind two hands shaking, that represents, that's a universal symbol for agreement. Well, it takes two people to shake hands. So anytime in any of these forms where you see notice, you know it's unilateral and you only need one party's signature. And where you see agreement, you know it's bilateral and you need both parties' signatures. Okay, we're almost done. Hang in there. Pop quiz. I said there wasn't a quiz, but you were not graded. The GAR contract is designed to protect whom? The RE Forms contract is designed to protect whom? So in the chat button, I want you to write GAR and whom you think the contract's designed to protect, and RE and whom you think the contract is designed to protect. Type that in the chat. Both buyer and seller, buyer, RE buyer, GAR seller, GAR broker, GAR agent and broker, agents and brokers, both parties, seller, brokers, consumer, buyer, buyer, seller, both. All right, you guys, your purchase and sale agreements and the standard terms, both in the GAR contract package and the RE contract package, are designed to protect you, the affiliated licensee, and me, your broker. They are designed to protect agents and brokers. They both attempt to be fairly equivalent in terms of the promises and responsibilities and consequences on both consumer sides, both the buyer consumer side and the seller consumer side. But design-wise, they are designed to protect you guys. All of this legalese that's in here, I'm going to go scroll way back up. All of this stuff, let me even start here. See here where it says brokerage relationships in this transaction? Buyer's broker is ABC Realty and is representing buyer as client, customer designated dual. Seller's broker is XYZ Realty and is representing seller as client, customer, blah, blah, blah. Guess why that's in there, you guys? That's license law in Georgia. It is a license violation if you do not disclose the brokerage relationship and which party you are representing as a client. That's why that's in there. It's to keep you and your broker out of trouble with Greg for violating license law. Here, down here, where it talks about earnest money, the deposit of the earnest money, I'm not going to be able to find it because I'm looking for it really quickly. Anyway, somewhere in here, it talks about the deposit of the earnest money, and it's in both GAR and the RE. Here it is right here. The earnest money shall be deposited into the holder's escrow or trust account, with holder being permitted to retain the interest if the account is interest bearing. Guess why that's in there? Yep, license law. It is a license law violation to not disclose who is going to get the interest if a trust account, escrow account bears interest prior to the deposit of those funds. That's in there to keep you guys and your brokers in compliance with license law. On and on and on. Same thing with the RE Forms package. The majority of the legalese that's in the contracts and the standard terms, including the fill in the blank for your license number and your firm's license number. Guess why that's in there? That's in there because that's for compliance with license law. So if you guys are a party to a HUD contract, new construction contract, attorney written contract, so forth and so on, you better be putting in your license number and your firm's license number, or you're in violation of license law. So back to my pop quiz question. These contracts are really designed to protect you as licensees and your brokers. All right, let's see if I have anything else that I have missed, and we are almost done. Nope. That was it for that, and that is it for that. All right, so just a couple of conclusions, just general differences. Again, regarding the fill in the blanks and the legalese, GAR has A, the fill in the blanks, B, the corresponding terms or the legalese, and then C are the other terms. The RE forms, the fill in the blanks are throughout the actual contracts, and the standard terms are the legalese. General reminders, you guys, a legal description absolutely is required in addition to a street address. Also, parties must get a copy of everything they sign. Make sure your closing attorneys and lenders, and please include your brokers in there. Make sure we also get a copy of all exhibits and amendments. Do not leave any blanks. Either fill in NA, meaning not applicable. If it has a dollar sign, you must put in $0. NA next to a dollar sign does not make change. A dollar sign, as we addressed earlier, is calling for numerals. NC means no change. That would be applicable on a counter offer. If the buyer and the seller are not negotiating, for example, a difference in closing costs, you don't want to leave it blank. You don't want to put NA because it is applicable. You don't want to put in the dollar amount because that's already on the original offer. So you would just put NC, meaning no change from the original offer. Do not use TBD or to be determined. You have to, that does not reflect a meeting of the minds, which is required for enforceability. For example, closing attorney, to be determined. Nope, you need to identify a closing attorney. If the contract is subject to financing, you must fill out all those terms per license law. As an agent, do not hang on to earnest money. You must get it to the broker as soon after receipt as practically possible. Complete your brokerage address and your email address or fax number on the signature page. It can be your branch or your corporate address. Check with your broker. Again, complete your license number and firm license number and agency representation. That's per license law. Regardless of who is holding the earnest money, I don't care if it's your broker. I don't care if it's the co-op broker. And I really don't care if it is the closing attorney. It is your responsibility, both the buyer side and the seller side, to follow up with that. Was it received? Was it deposited? You want to request proof of deposit regardless of the holder. All buyer and seller signatures are required. What I mean by that is if you have, we've had some situations where we've had some estates and there were 5 or more actual sellers. Every seller's signature is required. Don't miss any initial spaces. Check your contact information on the signature page for notice. And if you are working with, if it is indicated under the agency section that the broker is working with one of the public people, the public buyer, the public seller as a customer, then it is required to have either the email or fax or address of that customer. If the broker is working with the public person as a client, then notice to the broker serves as notice to the client as long as it's not a designated or dual agency situation. Please, please, please limit your special stipulations. Both the GAR and the RE forms have a whole special stipulation library that you have access to where you access your blank forms. Do not write a special stipulation for an issue already addressed in the contract. In other words, if you are in the RE forms, the appraisal contingency is in the purchase and sale. In the GAR forms, if a buyer is getting a loan, the appraisal contingency is addressed in the loan contingency exhibit. Don't add a special stipulation to your purchase and sale that says property must appraise for sale price, because a special stipulation supersedes the contract and an exhibit. And you have just, number one, you're not an attorney. And number two, well, what happens if it doesn't appraise? What kinds of notices? Are there termination rights? No, you have just negated all of that stuff in the exhibit and in the contract when you add your special stipulation that says property must appraise for sale price. It's already addressed. Don't write it. If you need help with a special stipulation, please get with your broker or a closing attorney. Again, check out the entire library of GAR and RE forms for other useful forms and special stipulations. Generally speaking, okay, wait, I've got one question. What is the definition of $10? So in some parts of the contract, you need what's called consideration for the legal enforceability of a contract. Consideration is something of value to the parties within the contract. The consideration of the GAR contract and the consideration of the RE forms contract in and of themselves are the promises that each party makes to one another. However, there are certain little things, for example, under the due diligence period, you'll see in consideration for $10, the receipt and sufficiency of which is hereby acknowledged. That just is a legalese thing because you need separate consideration, because in essence, a due diligence period is a mini option contract within the broader context of the purchase and sale agreement. So you need separate consideration. So it's just a something that's legally required for consideration. No, earnest money is absolutely not the consideration, because you do not need you do not need earnest money, but you do need consideration for enforceability. In the purchase and sales, it says the promises are the consideration, but in those other little mini options, it does say $10. The receipt and sufficiency of which is hereby acknowledged means it never actually changes hands. It's just a legalese. It's just a legal construct for enforceability of the contract. Okay, you guys, confirm all your contract questions with your broker. If you are a realtor with your NRDS number, you do have access to a legal helpline through on GAR's website. We have additional courses. Right now, they are all still being held for the most part virtually. So if you go to eagentweb.com and select calendar, that will be the main calendar for the virtual classes. We have a lot of, Maximum One is hosting the majority of the classes taught by the Georgia Real Estate Academy. There are many franchises of Maximum One throughout all of Atlanta, down south, up north, all over the whole state of Georgia, as well as Alabama. So they each have their own training calendar for some of their own in-branch classes. But what I'm giving you is the link for the virtual classes. Video recordings and handouts, if they exist, you can also go to eagentweb.com and select training videos and scroll through there. Again, the school is the Georgia Real Estate Academy, school number 6915. The majority of the Georgia Real Estate Academy classes are hosted by Maximum One Realty and Maximum One Realtor companies. Have a wonderful, joyous, prosperous, and healthy year helping others. There is a lot of need out there. Again, CE credits 3 to 7 business days. Once again, before you leave, please type in your name, email address, and your real estate license number. I do have a YouTube channel called Real Estate Made Crystal Clear, where I address all of these types of issues for both the GAR contracts, the RE Forms contracts, and license law on a much in-depth, more basis on just a limited topic. Please feel free to check out that channel. My target audience are real estate agents throughout the state of Georgia. So I would love if you would check that out and subscribe. I've got a lot of videos on there that are way ahead of any discussions that we have. And again, that's Real Estate Made Crystal Clear. And I am going to stop sharing my screen and I will answer any questions that anybody has. I hope you thoroughly enjoyed it. This was a lot. And again, the main difference was to go through everything. The main differences and similarities between the two contract packages. So I hope you guys feel much better educated so that if you initiate or receive an offer on a contract form that you're not necessarily have been familiar with, that is not quite so scary, and you understand the differences and can help your clients determine which contract package best suits their needs. What other CE classes do I teach? I teach the GAR contracts, the RE Forms contracts, license law, fair housing. There's a bunch of them. On that calendar, we have a lot of our brokers that teach a lot of our classes, and it should say who the instructor is, either on the calendar itself, or if you actually click on a class on the registration link, it will say that. We are in the process of completing March, April, and May's calendars. We've got some classes up there, but we have not finished with all the registration links yet. Why do sellers favor conventional financing over FHA? In FHA, the appraiser, if an FHA appraiser mandates repair issues, typically there's more repair issues required for a buyer getting an FHA or a VA insured loan, and those must be completed prior to closing in order for it to close. Conventional loan, there are some conventional lenders that are requiring repairs, but a lot of times a house can be in less repair shape and still get a conventional loan and than an FHA or VA insured loan. Any other questions? I always get at this point a lot. If you want to leave, you are free to leave. I always get a lot of people staying on to hear others' questions and the other answers. Any other questions, anybody? You can unmute yourself if you want to ask a question. I can't, you have to unmute yourself, Annette. I can't hear you. Oh, now you're muted. Try again.
Oh, hello. Can you hear me now?
I can hear you, Chevy. Yes.
Oh, how do we get the credit? Do you guys upload it automatically to for GAR, or how does that work?
Yeah, not to GAR, but to GREC, the Georgia Real Estate Commission. So within 3 to 7 business days, we will do it. We don't send you anything. Each agent, all of you guys have your own login with GREC. So you go to GREC's website and you go to online login or something like that. And you all have your own login with GREC where you can track when you're due for renewal and all of your CE credits, but it will show up there. If you are currently, if your license is currently active, your qualifying broker can check your CE credits on their roster as well. But each of you have even if you're inactive, you do have your own login with GREC where you can see the status of your education and your license.
Wonderful. I'm also on that website for the eagentweb.com. I clicked calendar, and then there's a whole lot of different locations on there, maximum one. Is there a particular link that I should be clicking after I click the calendar?
Yeah, so if you go there, again, we've got a lot of additional franchises. So if you go to eagentweb.com and you click on calendar, okay, gotcha. If you click on Marietta, that will give you the master virtual calendar for all the locations. Some of the other areas are holding different classes in branch.
Wonderful.
And once we actually, GREC has approved virtual classes through the end of the year, but some brokerages are choosing to have in-branch classrooms, workshops. So if one of those locations is nearer geographically to where you are, check out their calendar and see what they've got going on.
Thank you.
Yes, my pleasure.
Can I ask you, on the paperwork always say consider $10 on the contract. What's that really mean?
So it's just something legally for the terms to be enforceable between the buyer and the seller. But $10 never actually changes hands. They never actually exchange $10. It's just for legal purposes to be enforceable between the buyer and the seller.
I see. Thank you. And also, as if some agent turn in an offer on the RE form, and then I don't use RE form for the seller disclosure. I use the GAR form. Can that be mixed like that? Exhibit on GAR form and the real contract on the RE form. Can that be mixed?
So a couple of things. You bring up a couple of good questions. One is, let's say you receive an offer on whichever package, either the RE forms or the GAR forms. If your client doesn't like what's pre-printed in there, your client can rewrite everything on a completely separate form and make that as a counter offer. Let's say you represent a seller and you receive an offer from a buyer on an RE form. You discuss with your seller what's going on. Let's say the seller's fine with the price, closing costs, everything, but they want the 8-day unilateral right to extend or something like that. The seller can rewrite all the terms on a GAR form and send it back to the buyer. Their counter offer would consist of rewriting the entire contract on a different form. That would be a counter offer back to the buyer. Then the buyer has to decide if they want to sign it or make a counter offer back to the seller. So that's one question. The other question is, let's say you get an offer from a buyer and it's on an RE form and you represent the seller. The seller already had the GAR seller's property disclosure form filled out. Yes, you may counter back, not changing anything to the main purchase and sale agreement, just adding the GAR seller's property disclosure form as your counter offer back to the buyer because you want to include that in the contract. So as long as, so you can do the mixy-matchy as long as something does not negate something that's in the actual body of the purchase and sale that they are agreeing to.
Yeah, I agree, because the GAR form is much easier to see all those input. It's only on the first page and the last page where the people put the stipulation couple line on there. But the RE form, there is several pages need to fill in. And also I feel the RE form is a little bit dumb. They even make the people to initial on the last page, which is seller, buyer side, and agent side. And those need to be initial too, that page. I feel like That really make no sense to initial on the page that your signature go on. Have you noticed that?
So yeah, they have that too.
Yeah,
but
the fifth page.
It depends on your perspective. As a broker, I hate all the fill in the blanks on page 1. I absolutely hate it because it, generally speaking, not for anybody here in this class, generally speaking, it negates for good customer service, because when the fill in the blank is throughout the contract in the paragraph, it at least prompts a mini discussion from the agent to the client. Look, this is what closing costs is, and this is what it means. This is what happens. This is this is the date of closing and possession, and here's what that means. You have to be out by X p.m. So it prompts a mini discussion about that. And the GAR form used to be like that. So it depends on your perspective.
Yeah.
Is it more
convenient? Yeah.
Is it more convenient to look at one page? Yes. For customer service, I like it sprinkled throughout because I know
agree. But RE form is not enough. RE form doesn't have the closing attorney hold the money or all cash exhibit. RE form doesn't have those form. Yeah. So we have to mix with GAR form, something like that. Yeah, I agree. Thank you for your time, Ms. Park. Yeah, thanks. Okay. You have a good day. Okay.
You too. Annette, I can't hear you. I can see your mouth moving, but I can't hear you. You're not muted, but I don't know why I can't hear you. You want to type? I can see your mouth moving and you're not muted, but I can't hear you. Is there, while you're figuring that out, is there a class that covers everything that needs to go in a closing package from the realtor? Monica, I'm not sure I don't know what you mean by that, if you're still on. We do have a class called Show Me the Money and Get Me to Closing. That might have everything, like an addendum and all that stuff. So regarding what goes in your actual purchase and sale agreement, what exhibits and amendments and so forth and so on, that's really going to be up to your broker. Many brokers have a checklist that they would use, but we don't really have a class on that, other than, like I said, we do have a class called Show Me the Money and Get Me to Closing. That is just a general class regarding the lending process and the closing process and kind of what's required in that. We have another class called Contracts, Offer, and Acceptance. That is more of a I guess kind of what you would use in a purchase and sale agreement, and what exhibits you would want to consider, and amendments and so forth and so on. Yeah, Show Me the Money, Show Me the Money and Get Me to Closing. That's a good class. Annette,
I have a question.
Okay. Hi, Pamela.
Hi, I have a question. During the training session that we just had, you mentioned the TREAD, and you were stating that if the lender doesn't have it available or ready, because we were thinking that was, you were saying that was a federal issue, so the due diligence has nothing to do with it.
No. So TREAD stands for Truth in Lending, RESPA Integrated Disclosure. And there was a set of laws, the Frank-Dodd laws came into effect. This portion of it came into effect in October of 2015. And basically what it says is for lenders and closing attorneys, they are federally prohibited from closing a transaction if the lender has not sent out to the buyer consumer 3 days in advance of closing these certain financial disclosures. Now, it's not the money to the penny. The money to the penny, the cash to close can change. The HOA fees can change. Property taxes can change. Some of that stuff can change because we're closing. Closing might be delayed or close early. but they are basically lender fees that are non-negotiable fees, or once they're established, they are established. Like, I can't think off the top of my head what's included in there, but the lender must disclose to the consumer their non-changeable fees within 3 days of closing, or the lender can't close it. That
and that was my question. That was my question. Not so much of the terminology of it, but let's say it was the lender's delay, because they hadn't issued it or whatever, so they've delayed the closing. So if the lender delays the closing based on the TRID not being submitted or issued,
right,
between both parties, buyer and seller, what do we do at that point? Because it's the lender that's delaying the process.
So if you're binding under the GAR contract form, you would use the 8-day unilateral notice to extend, because that is one thing that is specifically allowed for, that if the delay is caused by the lender, as long as that delay is not the fault of the buyer. So in this situation, like, that clause is in there for either the lender is just inundated and the file is not out of final underwriting yet, or they have not sent out that TRID disclosure within 3 days of closing. That is one of the things that is specifically itemized as a reason for a party to use the 8-day unilateral extension to closing.
Okay.
So now that notice to extend it must be sent out prior to 11:59 p.m. of the last day of closing, and you're extended to the 8th day after your closing date. Now, if you're binding under the RE form contract package, there's no unilateral right to extend, but the lender and closing attorney still cannot close it. So that's what I went over in that. So what happens is the buyer sends the seller a notice that says, look, I just got word from my lender, that they never sent out the TRID. They haven't sent out the TRID disclosure yet. We cannot close on February 24th. We have to close on March 4th. If you're binding under the RE Forms contract package, the seller can say, nope, sorry, I don't agree, I'm terminating. The seller has 3 days from getting that notice that the lender can't close it to terminate, and the buyer's just out. Or if the seller doesn't send anything within, so the buyer sends a notice saying, hey, we can't close tomorrow, but we can close March 4th. If the seller doesn't terminate within 3 days, then the seller agrees to that new closing date of March 4th. That's how it works in the RE forms.
Who gets the earnest money, in your opinion?
I think in that situation, you would terminate based on other lawful reason that the parties, the lender and the closing attorney, were federally prohibited from closing. And if the seller chooses to terminate, I think the buyer would get the earnest money back. That's my broker opinion. But if there is another broker holding the earnest money, it would be up to their interpretation of the contract.
Right. Okay. Thank you.
You're welcome. I still can't hear you, Annette. I'm so sorry. I can see that you're trying to talk and you're not muted, but I don't know why. Can you type it? Too much? I'm so sorry.
Maybe if she stops her video and restarts it back again, it might unfreeze that.
All right, we'll try. Anybody else? Any questions? It's probably the besterest question in the entire world, too, and we can't hear it. Anybody else? I thank you guys so much. I appreciate your time and attention. Annette, you can always email me, Dana@MaximumOneRealty.com.
Thank you so much, Dana. We appreciate it.
Thank you guys so much. Look forward to seeing you guys in another class. Lots of people need your help in this crazy market.
We look forward to getting your handouts.
They'll be emailed to you. We're going to email you guys the handouts.
Thank you.
Thank you. Thank you, Ming. Hope it helped. All right, everybody. I'm going to end the poll.
Thank you, Dana.
Thank you, Kay. Good to see you. Happy New Year to you.
Same to you.
All right. Stop recording.